Hello, doctors. I'm Dr. Chris Rapoff of QME Continuing Education, and welcome to this week's Case Law Update. In today's Case Law Update, once again, we discover how important it is for a QME report to qualify as substantial medical evidence. This week, we also discover how important it is for the QME to have a firm grasp of the labor codes, as those codes apply to each and every medical legal report. This week, we also had a QME that had a revelation while he was being examined during a deposition. So what was this revelation, and did it have an impact on the outcome of the case? Let's take a look. In the Rios versus Modern Method Roofing case, the defense counsel seeks reconsideration of a findings and award with an opinion that is dated June of 2022, which, in addition to the accepted body parts, they found injury, AOE, COE, to the applicant's heart and lungs. More about that later. But in the form of obstructive sleep apnea, also obesity and hyperventilation syndrome, and right-sided heart failure. And thus they awarded the further medical treatment for those body parts. Now, how was this possible? That's what we'll get into. So today's petition alleges by the defense that Number one, the findings and award are without or in excess of the workers' compensation judge's powers. Number two, that the evidence does not support and justify the findings of fact. And number three, that the findings of fact do not support the award. Now, the defendant also asserts, and really has a pretty substantial argument, that the final opinion of a pulmonary QME, which admittedly changed over time as to the injury AOE COE for the disputed body parts of heart and lungs, it was not substantial medical evidence, and because the applicant was already overweight at the time of the specific injury, and that the opinion cannot be the basis of a finding of injury or AOE COE to those body parts because it was not sufficiently explained in the report. Now, as some background, Mr. Rios sustained an accepted specific injury to his low back, his left hip, and right ribs and right clavicle in July of 2015, while he was employed as a roofer for Modern Method Roofing, when he fell while carrying a roll of roofing material, which ended up on top of his chest, crushing his torso. Now, the initial primary QME is a pain specialist, and they evaluated and accepted the orthopedic injuries, and they were not disputed. But Mr. Rios later alleged that his heart and lung pulmonary injuries, either as a direct result of the specific injury and or as a compensable consequence of the original injury. Mr. Rios was then evaluated for that claim by a QME, another one, and the defendant agreed with the applicant's request for an additional panel in pulmonology. So a pulmonary QME examined Mr. Rios once and issued a total of 6 reports and was deposed once in March of 2021, 6 years after the injury. Now, the original QME was a pain specialist, and in his initial report in November of 2016, they found that the applicant was not yet PNS for his orthopedic injuries. He also incidentally referenced shortness of breath complaint in his report. Now, the QME found Mr. Rios to be PNS at that time for the orthopedic injuries and impairment ratings. He also diagnosed Mr. Rios with a pulmonary contusion and suggested that, quote, it would not be unreasonable to have a pulmonary consultation with respect to Mr. Rios' complaints of nocturnal cough with shortness of breath. Now, those conditions were subsequently evaluated by a consulting pulmonologist in 2018, 3 years later after the injury, and made the diagnosis of dyspnea, daytime hypersomnolence, with strongly suspected obstructive sleep apnea, GERD, and obesity. And he also reported in his report that he had a weight gain. Mr. Rios gained weight of 30 pounds in the past year. At the time of his first report, he said Mr. Rios was weighing about 245, and at the time of the second visit with another QME, In 2019, his weight had increased to 260 pounds. By the time the QME examined Mr. Rios in August of 2020, Mr. Rios was weighing 262 pounds. Now, Mr. Rios testified at trial in February of 2022, which was 7 years after the accident. And with respect to the key issues of his injury to his heart and lungs, he had breathing problems immediately after the injury, and upon release of the hospital, he was given a device and instructed to perform breathing exercises with it by exhaling to keep the ball in the air inside the device. Of course, it's a spirometer. Over time, he reported that his breathing problems did not abate and were actually getting worse, and he sometimes would wake up with a choking sensation. So once post-injury, he had to go to the ER because of breathing issues, and he believes that they haven't increased and gotten worse since his weight has increased over time. He has denied any problems with snoring or shortness of breath prior to the injury in 2015. Now, as part of the discussion here, the defendant's petition is that the QME's opinion on the injury, the AOE-COE aspect, with respect to the heart and lungs, is not substantial evidence because he didn't sufficiently explain or provide a basis for his mechanism of injury theory. And the injury theory was that Mr. Rios gained a significant amount of weight post-injury as a compensable consequence of accepted orthopedic injuries. Now, as a result, this reduced and limited his physical activity level, and in turn contributed to the development of obesity, hyperventilation syndrome, and right-sided heart failure. Now, it is true that the QME did not come around to this opinion until his deposition was taken in March of 2021. That was after 3 reports were already written prior to this deposition. And at the deposition, when the light seemed to come on as to the concept with questioning by Mr. Rios' attorney, specifically that because Mr. Rios decreased physical activity due to the accepted and physically limiting orthopedic injuries, those injuries contributed, at least in part, to his significant weight gain after the injury, thereby resulting in a compensable consequence injury to his pulmonary system and heart. Now, it is undisputed that the QME's first 3 reports, he specifically and explicitly found that these respiratory and pulmonary heart issues were not industrial, and that's as the result of an AOE-COE situation as a compensable consequence, because he says Mr. Rios was already overweight at the time of his injury. However, and as the QME testified in his deposition, it's consistent with Mr. Rios' trial testimony, and he did not have any breathing and or pulmonary issues prior to that injury. So the defendant's petition cites no evidence, medical or otherwise, to the contrary. Okay, so the defense is actually alleging that the workers' compensation judge erred in his finding that the original QME opinion on the subject, which changed during the deposition and which he later stood by in 3 supplemental reports, is substantial medical evidence and was a proper basis for the findings and award with respect to the AOE-COE injury to the heart and lungs. So a little review here. Now, to be substantial evidence, we need some parameters. First, you need an expert medical opinion that must be framed in terms of reasonable medical probability. It also must be based on an accurate history and an examination, and must set forth the reasoning used to support the expert conclusions that were reached. In addition, a medical opinion is not substantial evidence if it's based on facts that are no longer germane, or inadequate medical histories or examinations, on incorrect legal theories, or on surmise, speculation, conjecture, or guess. And they feel that and believe that the record of those requirements were met. Now, most importantly, when we're assessing industrial causation of an injury, the closely related question of proximate cause The leading California case to keep in mind is South Coast Framing Incorporated versus Workers' Compensation Appeals Board. Now, in that case, the Supreme Court makes clear that essentially any measurable and or discernible amount of causation or contribution to a new injury by the consequences of an accepted injury, as in this case, is sufficient to render such an injury industrial and as a compensable consequence. Now, while there might be some significant other causal factors in this case that caused or contributed to Mr. Rios' weight gain, those go to the issue of apportionment and related to the pulmonary and heart injuries and not to the injury AOE-COE. Additionally, in the South Coast Framing, the court also made clear that whether an industrial injury and or its consequences proximately caused a later injury within the meaning of the Labor Code Section 3600 is a question of fact for the judge to determine based on all the evidence in the record, which he did make that determination. The appeals board continues, and they indicate that applying the holdings of this case law to the facts of this case in their judgment results in an inescapable conclusion that Mr. Rios' well-documented and significant weight gain after the injury, as reflected both by the pulmonary QME and in the original QME reporting and the deposition testimony of the latter, as well as Mr. Rios' trial testimony, they concluded that there was sufficiently causal of the breathing pulmonary heart symptoms and the conditions to render them compensable consequence injuries of the underlying accepted orthopedic injuries, which reduced his ability to be physically active and burn calories as he did when he was working as a fully healthy worker. And they weren't done. They also said the bottom line of this record in this case clearly establishes by the preponderance of the evidence that Mr. Rios gained significant weight after the accepted orthopedic injuries, even if he was already overweight at the time he sustained an orthopedic injury. They say it's also undisputed that Mr. Rios is currently obese at approximately 265 at 5'8", and that in the opinion of the original QME, that weight is causing and contributing, at least in part, to his pulmonary and cardiac symptoms and conditions, which concludes are compensable consequence industrial injuries, and that in turn these require medical treatment and weight loss to ameliorate and or cure. Now, contrary to the defendant's assertion that the original QME's later opinions of the post-injury weight gain is due to inactivity from the orthopedic injury, is not a reasonable conclusion to derive from the evidence. Now, the QME was consistent, they concluded, once he changed his mind in the AOE-COE issue, despite the defense counsel's repeated efforts to get him to return to his original opinion on causation. If you recall, he had 3 reports prior to his deposition and then 3 supplemental reports after. They also state that it's worth noting that although they find the defendant is liable for a new compensable consequence injury to the additional body parts, as we talked about, there likely will be significant apportionment of any resulting permanent disability once Mr. Rios reaches permanent stationary status and impairment or permanent disability is determined. In their final conclusions of the Workers' Compensation Appeals Board, they indicated that having read and re-reviewed all the reports and his deposition testimony, the QME, they think, has a fair characterization is that up until the deposition he had a misunderstanding of applicable law and he was resistant to finding injury for the pulmonary conditions, but that once he understood that even some weight gain due to the reduced activity and physical limitations from the accepted orthopedic injuries was legally sufficient to establish injury, he was and has been consistent with his opinion and conclusion as such weight gain was at least in part caused or contributed to by the effects of the orthopedic injuries. It took 3 prior reports before the deposition, and then once he had the deposition, his opinions and conclusions changed, and they did not change from there forward. So accordingly, they conclude that the work comp judge conclude that the original QME's opinions were substantial medical evidence, and which they arrive and find the injury of the AOE-COE to the applicant's heart and lungs in the form of obstructive sleep apnea, obesity, hyperventilation syndrome, and right-sided heart failure. So the recommendation was that the petition for the reconsideration of the findings and award of 2022 was denied. So in this week's case, we further drills into our heads that as we wear the QME hat, being proficient in our understanding of the labor codes, and also learn that it is possible to evolve in our opinions and conclusions, just as this QME did. So doctors, once again, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to sharing some other interesting cases with you again soon. Until then, thank you.